Hello, welcome to Lowbugs. Today we'll deal with Ejusdem Generis or Law Tenderness rule. Both are one and the same. It is one of the important topics in the interpretation of statutes. You can be asked in question papers, what is Ejusdem Generis or what is Law Tenderness rule? Both are one and the same, and what that means is simply means that of the same kind or species. So let's move on to our video. We'll see the details. Let's get started. So what does Ejusdem Generis mean? It simply means of the same kind or species. It's also called a broad tense rule, as I mentioned earlier. Okay. Now, this is one of the important topics in interpretation of statutes. What it says is that where there are general words following specific words, the meaning of the general words must be confined to the things of the same kind as specific words. So there will be some general words of some things. It has to follow some specific words and should be confined to the things of the same kind of specific words. Then only it can be said it will come under the purview of Ejusdem Generis or Law Generis rule. So it can be easily explained with an example. Okay, so we'll see an example so that you will get a better idea. So the example is we can see motor vehicles, right? So there are very different kinds of motor vehicles like trucks, tractors, motorcycles, etc. Automobiles. You can I meant automobile. There are different kinds of automobiles like trucks, tractors, etc. All are land-based, right? But if you see airplane, it is also an automobile. It is used for transportation as the others, but it is air-based. So what is the difference? One is air-based and other is land-based. So it cannot be held as, even though it is under automobiles, it cannot be said that it is under Ejusdem Generis because it has to come under the same kind or same species or same class. This is the important thing. Now, the next example you can see is that apple, orange, banana and such other fruits should be taxed. So here, such other fruits is a general term. So it is limited to specific words, right? You cannot say apple, oranges when you specifically say something. It is mentioned that okay, this fruits. But when such other fruits is that what are the such other fruits? It's not mentioned. So there is no clarity on that. I hope the example is clear. So when a law lists class of persons or things, this concept is used to classify such list. Okay. So this is Ejusdem Generis. Now the ingredients. The statutes contain what are the ingredients or condition? There can be many conditions as well as ingredients, and what are the very important things? So there are some of the ingredients mentioned for this. So the first ingredient which you can see is that statutes contain an enumeration of specific words which constitute a class. The statute, there should be a statute and there should be an enumeration of specific words, and there should be enumeration of specific words and it has to form a class. Then only the Ejusdem Generis rule. As you can see the example so that you can understand what that means. So the next ingredient is subject of enumeration should belong to a class. So class is a main, everything should form a class and it should form under the specific words. Okay, then only the meaning of Ejusdem Generis can be taken up. Class or category should not be exhausted. That is, specific words should form a class. There should not be any exhaustion in the class or category. General words should follow the specific words. As the meaning says that they should follow the general word must be there. It should follow the specific words. You cannot deviate from it. And the last is it should not be mentioned in any other statute or legislation. The general term must be read in the same context and belong to the same class. and the same things should not be in any other statute. It has to be in a one and go. They should not be mentioning in any other statute of this. And the main thing is it should fall under the specific category and it should form a class. Okay. Now there are some exemptions. You can see some exemptions, that is, if the preceding term is general, the Ejusdem Generis will not apply. When you can see when the words are in a general things, if it is like automobiles, what are the automobiles we cannot say, but we can have to say there should be a category like land based. Okay, so if the preceding term is general, the Ejusdem Generis will not apply. The other exception is when particular and specific words exhaust the whole genus, there is nothing left in Ejusdem Generis. So there should not be any kind of exhaustion. If it is exhaustion, you can see some exhaustions of this, then this comes under exemptions. The next one is the general word shall not be restricted in meaning by the specific words. There should not be any kind of restrictions. If there is some restrictions, then it will not come under the category. Okay, now the next we'll move on to the case laws. So case laws, first is Ratan Singh Hirji versus Emperor. Here you can see Section 412A of Bombay Municipal Act required a person to acquire license before he uses any place for the sale of milk, butter or any other products. Okay, so you have to have a license if you're dealing with some products. If you have to sell it, you have to get a license. That was the rule. And in this case, Ratan Singh was a merchant who was selling ghee without obtaining license. The state prosecuted him for not getting license. So when the rules say you have to get a license, without getting a license, if you do a business, it's not. So the you can see that state had prosecuted him. What is the question before the court? It was that whether ghee would come with the expression of other milk products and if license is needed to sell it. So there was a question if the ghee comes under the purview of the expressions of milk products. So what the court held? The court held was that other milk products should be seen with reference to what preceded those words by applying Ejusdem Generis rule. That was, ghee is not the same kind or the same nature of milk or butter. That is, milk and butter are liable to speedy decay. That was the thing that the court observed. It is liable for speedy decay. So, but ghee is not liable for speedy decay. Thus, it is not the same kind of product like milk and butter. So, milk and butter can be decayed, it is perishable, and ghee can be stored for some time. So, it does not come under the same kind of thing. This was a observation of the court. The next case is UP Electricity Board versus Hari Shankar. In this case, court held was what the court was all the ingredients or the conditions of Ejusdem Generis was followed or not. What was all the condition? As we have seen earlier, the statute contain an enumeration of specific words which constitute a class. A class or category should not be exhausted. General words should follow the specific words. It should not be mentioned in any other statute or legislation. These all things were seen by the court, and say if all the ingredients come under this category to solve this case. Okay. Now, the next case which we can see here is Circuit City Stores Incorporation versus Adam. Here, Supreme Court defined Ejusdem Generis as a situation in which general words follow specific words in a statutory enumeration. Okay, here this was the observation of Supreme Court. The general words follow specific words in a statutory enumeration. The general words are constructed to embrace only objects similar in nature to those objects enumerated by the preceding specific words. So general words are constructed to embrace only the similar kind of nature of products, and there has to have a general word. Fruit means this, and you cannot say such other fruits, right? Any kind of fruits can come. So for any kind of things, there should be mentioned what are the things coming under that. If there is no other mentioning of that, it the code like cannot be applied. Here in new railway versus train dispatches, Ejusdem Generis does not apply. When the court, the whole context dictates a different conclusion. So details such each word's details another meaning. So here the Ejusdem Generis will not apply. If you are asked Ejusdem Generis what which in which case it does not apply means there is no way there was a train dispatches. Now when you are writing your exams or some, if you are mentioning what all cases the cases Ejusdem Generis apply and what all cases it does not apply. Okay, so these are the two kinds of cases in which it is applied and this is not applied. Now the next case is Calcutta Municipal Corporation versus East India Hotels. So here you can see section 443 licensing restaurants within the permit of five-star hotels having dancing floors. Guests allowed to dance here. Okay, so this was whether the restaurants all come under the same category or the dance floors and all come under same category or license are needed for this. This was the contention which came under this before the court. So, Calcutta Municipal Act 33 of 1951, Section 443, licensing restaurants within the premises of five-star hotels having dancing floor. Guests were allowed to dance there, and the similar kind of occasions were occurring there. And the person's condition was that it was not under the purview of restaurants or whether license are needed for that or not. But a dancing hall cannot operate without obtaining license under 443 of the Act. What is a dancing hall? If you can see is that dancing hall as understood in an ordinary, this is that where dancing floor is provided and live orchestra or music in any other form is played to entertain the guests who wish to come on the floor and dance. Then dancing hall are peculiar to the Western social life. In the cosmopolitan cities in the country, even today, one finds number of dancing halls and where the people go in the evenings and entertain themselves. There is no difference in the dancing hall and restaurants. So here you can see if you are a dancing hall, there is some kind of puddings and all, right? You are getting some lectures, you are getting like entertainment, everything. So this under the purview of the restaurants. So there has to have a license and the license fee has to be paid. This was the conventions. So summing up, we can say that Ejusdem Generis simply means of the same kind or species. You have to see is whether the court observe is that whether this come under the same category or same species of things or the same kind of things, then only Ejusdem Generis rule will be applied. Otherwise, it will not come under the Ejusdem Generis rule. Okay, now that's all for today. We'll see you in the next video.